Good afternoon to those of you on the East Coast, and to those of you on the West, good morning. Welcome all, and thank you for joining us for today's webinar on patent strategies for pharmaceutical technologies. Penny Farbey is a special counsel in Wrays Life Sciences Group and has been with the company for 19 years. I'm an associate that works closely with Penny in Wrays Life Sciences Group. Prior to joining Wrays just over 2 years ago, I was a supervising examiner and hearing officer at the Australian Patent Office, aka IP Australia. And prior to that, I was working at Novartis in Basel, Switzerland, doing contract synthesis in their Kilo labs. By way of overview, you could flick to, thanks Penny. Penny and I in today's webinar will be alternating through and touching briefly on each of the topics of patent support, deadlines, extensions and highways, any options that you might have to protect your IP still if getting a patent is not available to you, and searching for the purposes of freedom to operate and searching by monitoring the Australian Register of Therapeutic Goods. We'll also provide some time for any comments or questions at the end of the session. I'll handball over to Penny now to kick off with the topic of support.
Hi everybody. As you're aware, a patent has to contain a description of the best method for carrying out your invention. You can't keep one of the essential steps of your process or invention a secret there must be full disclosure. It's vital that the examples and the support that you provide in your specification are commensurate with the scope of the claims that you have. If you have a broad claim, such as the orange line on the slides, you have to have a number of examples to support that breadth. For example, the darker blue arrows that span the breadth of the claim that you're trying to gain protection of. If you had a narrow claim, one example might be sufficient, the lighter blue arrow. Regardless of the scope of your claims, you can't claim what you haven't supported and enabled. However, you can have reasonable extrapolation. You don't need to have an example of every way that something can be done within the scope of your claims. For example, if the specification shows an example of extraction of a compound using ethanol, it's reasonable to extrapolate the claims to include other organic solvents with similar properties, such as solvents that have a polarity similar to the polarity of ethanol. But this must be extrapolation that would be reasonable to the skilled reader, not wild speculation. If broad data isn't available, support can be provided by scientifically plausible reasoning. Using the previous example, the inclusion of additional organic solvents with similar properties would be better supported if the similar properties of the solvents and why they might be equivalent to your ethanol is discussed in the specification. Another support aspect is principles of general application. So a feature in the claims that's defined in general terms can be a principle of general application, where it's reasonable to expect or predict that your claimed invention will work with anything that falls within that general term. And claims that contain a principle of general application feature are sufficiently supported if the specification teaches you at least one way to perform that general principle, and two, has enough information for the skilled reader to think of and use alternatives that, although they might not be explicitly disclosed, will be obvious to the skilled reader. In a more specifically pharmaceutical area, the support needed that you need for further first and further medical use claims varies between Europe, the US, Australia and New Zealand. So a first medical use claim is something like compound A is known as a compound, but it's never before been used for medicine. So in Europe, you have claims of the form compound A for use in medicine, so to treat or prevent any condition. In Australia, You can have compound A when used for the treatment of type claims, method of treatment claims, and Swiss style claims, but they're for a specific condition, and you must have experimental support. But that support can be the plausible extrapolation principle of general application that I previously described, plus post-filing data, so data that you generated after the filing of the application, but that supports your specific condition that you're claiming now. In the US, the claim form is a method of treatment claim only. You can't have Swiss style claims or compound A when used. And you must describe a specific condition, and you again must have experimental support, but it can again be the plausible extrapolation principle of general application plus post-filing data. Whereas in New Zealand, the only claim form available is Swiss style claims, and you are restricted to a condition, and your claim must be fully supported by experimental data that is in the specification at the time of filing. You can't use post-filing data in New Zealand. Then we come to further or second medical use claims. This is repurposing of drugs. So compound A is known for its medical use, but it hasn't been used to treat condition B. So we're repurposing a gout drug for a heart medication, for example. In Europe, again, you get compound A for use in the treatment of condition B. So it's narrower claims this time because you can't have any method of treatment as some methods are already known. You must have experimental support, but you can have plausible extrapolation and post-filing data. Australia, again, you get compounds when used for, method of treatment and Swiss style claims, and your support can be plausible extrapolation plus post-filing data. US, you only have method of treatment claims available. You can use post-filing data. And New Zealand, you only have Swiss style claims to the treatment of condition B. And again, it must be fully supported by experimental data at the time of filing. And now I'll hand over to Dan to talk about deadlines.
Thanks. We're just going to do a brief comparison of the various prosecution deadlines between Australia and New Zealand to try to illustrate a key difference in New Zealand practice that may affect you. So the first key deadline that you'll encounter when you're prosecuting your application in either jurisdiction is the deadline for requesting examination. In both Australia and New Zealand, the final deadline for requesting examination of your application is 5 years from filing. And it's important to note that when we say filing here, we mean the effective filing date of the application, which is actually the filing date of usually your PCT application upon which national phase entry was based. So for these purposes, it's your international filing date. Generally speaking, it is possible to request examination at any stage after you've entered the national phase. In Australia, there's the additional complication that in order for the Patent Office to manage their workflow and balance it with their available resources, the Commissioner of Patents issues directions to request examination. And if you receive a direction to request examination, then you must request examination within 2 months of the issuance of that direction. And almost invariably, this occurs well before the 5-year deadline. In New Zealand, on the other hand, you often will not hear anything from the office about the need to request examination until you come very close to your 5-year deadline. So it's strongly advisable, as we'll see for further reasons that I'm going to talk about, to request your examination in New Zealand early. The next key deadline is the deadline for acceptance, and in both jurisdictions, that deadline is put in place upon issuance of the first examination report for your application. So when the first examination report issues in both Australia and New Zealand, you have 12 months in which to place the application in order for acceptance. That is, to render it allowable and overcome any outstanding objections that the examiner may raise. Now, that obviously might take responding to more than one report. In New Zealand, there's the extra complication that when that first report issues, it puts in place a 6-month deadline to respond to the report. There's no such deadline in Australia. Indeed, it is possible to simply respond to the first examination report a day or two before the final deadline for acceptance. But if you take that approach, you want to make sure that you're going to place it in order for acceptance by the deadline. So it's a risky approach to take. The next key deadline that's important for patent prosecution is when can I file a divisional for my application? In both jurisdictions, it's more or less true to say as long as the parent application is still pending, you can file a divisional. But the difference is that in New Zealand, it must be filed prior to acceptance, not grant, acceptance of your parent application. And it cannot be filed more than 5 years after the international filing date. So this is a really important difference. If you consider that you may not have even requested examination yet and you're approaching 5 years from filing with your New Zealand application, what if in your PCT application a lack of unity objection was raised? You know, one of the key reasons for filing a divisional application is that an alleged lack of unity has been raised, so the examiner considers that there's more than one invention in your patent specification. Under those circumstances, it's quite common to file a divisional to pursue an additional invention. If you haven't even yet received an examination report from New Zealand, you don't know whether a lack of unity is going to be raised. But you can almost guarantee that if in the international phase, the international examiner took a lack of unity objection, that the New Zealand examiner is going to take the same objection. So if that's the situation, it's strongly advisable to file a divisional for each invention, each alleged invention in New Zealand, because you're going to have to request examination on all of them before 5 years from your international filing date. If you don't take that approach, then you may lose the opportunity to pursue those additional inventions. Turning to the next slide, I'd like to speak briefly about extensions of time that are available in the two countries. Another deadline, of course, is deadlines for paying your renewal fees, your annuities. Most countries do have a 6-month grace period for paying your renewal fees late, but almost invariably there's additional costs that accumulate with time. For example, in Australia, for every month that you pay your renewal fee late, an additional official fee of $100 is incurred, to a maximum of $600 for being 6 months late, after which your patent will cease because you've failed to pay your renewal fees within the grace period. Extensions of time to perform an act are available in Australia. It's important to remember that our legislation only provides for an extension of time to perform an act on the part of the patentee or their representative or the applicant. So you can seek an extension of time to pay a renewal fee. You can seek an extension of time to file a divisional application, and you can seek an extension of time to enter the national phase in Australia, because these are all acts that need to be performed by a certain date. But you can't seek an extension of time on the deadline for acceptance for your application, because that is not performing an act on the part of the applicant or patentee. It's the Patent Office that chooses whether or not to accept your application. In order to apply for an extension of time, it's necessary to file a statutory declaration that sets out the timeline of events and the circumstances that led to usually an error or omission is the easier approach, keeping in mind that decisions in the past have found that an error or omission can include simply an error of judgment or even memory loss. But it is also important to demonstrate in the declaration that the intention was always there to do the act, whether that act was paying a renewal fee or filing a divisional. Similar provisions are available in New Zealand, but they're almost invariably more stringently applied, and it's very difficult to obtain extensions in New Zealand for the most part. Turning to the next slide, I would like to talk briefly about how you might expedite examination of your application. Many countries, including both Australia and New Zealand, have or participate in a program called the Patent Prosecution Highway, or PPH for short. And this allows you to expedite examination based on the examination of a related application in a different major jurisdiction. The US, Europe, also Japan, pretty much most major jurisdictions are accepted. Indeed, in fact, if you've had a claim set deemed allowable in the international phase and you have an international preliminary examination report, that can also be used as the basis to expedite examination in both Australia and New Zealand. The requirement is that the claims must sufficiently correspond, depending on the foreign examination report upon which you wish to rely, or the foreign application upon which you wish to rely. It may be that all claims must sufficiently correspond, or in some instances you only need one or more claims to sufficiently correspond. And I guess, what do we mean by sufficiently correspond? An illustrative example is provided by New Zealand. If you recall that because method of treatment claims or method of medical treatment claims are not allowed, they're prohibited by statute in New Zealand. For example, if you had some allowed claims in the US, they would read a method of treating condition A by administering compound B, for example. So in New Zealand, those claims would have to be reformulated into an acceptable format. And as Penny discussed earlier, Swiss-style claims are allowable in New Zealand. So if those method claims were reformulated into a purpose-limited medicament claim, then that would be deemed to sufficiently correspond and could form the basis of a expedited examination under a PPH program in New Zealand. There is an alternative in both Australia and New Zealand referred to as ordinary expedited examination, and in short, a common reason for getting away with requesting ordinary expedited examination is for the applicant to assert that they require the application to be prosecuted quickly because they have a commercial interest in doing so. So a commercial interest in expediting examination may be, for example, the need to commence infringement proceedings against a competitor. So New Zealand also has such an ordinary examination provision, offered on similar grounds to those offered by IP Australia. However, the bar to successfully requesting expedited examination in New Zealand is set rather high compared to that applied by IP Australia. In general, you get the impression that New Zealand is not exactly pro-patent, but I feel that some of these issues arise because IPONS is quite under-resourced, and so that they don't wish to bring forward lots of examination because they really don't have many examiners to deal with the workload. I'm going to handball back to Penny now.
Okay, I'll have to start rushing through this a little bit. So, what options exist if traditional patents are not suitable or available for your IP? One of the options that's available at the moment is an innovation patent. They are cheaper, quicker and easier to get than a traditional patent. And they are still available until August 2021, but they're being phased out after that. However, if you file an innovation patent before August 2021, then that will be maintained. It doesn't suddenly stop existing, it's just you can't file them after August 2021. We don't have time to go into innovation patents at the moment, but if you're interested in them, just contact us, email or phone. Another method that's more pharmaceutical based is our Therapeutic Goods Administration, or the TGA, holds a data exclusivity. There is a data exclusivity protection by the TGA. Data exclusivity means that some of the information provided to the TGA, such as clinical trials, safety and efficacy data for a new active agent that you filed to obtain regulatory approval, that information remains confidential and can't be accessed or referenced by a third party for 5 years. As a result, if you don't publish your clinical trial data, your competitors will have to wait for 5 years until the exclusivity period ends before they can use your data for comparison to achieve generic registration of their product. Another thing that people often don't consider is you might not have an IP position right at this moment, but could more research lead to an IP position? Have you really done the searching to determine the holes and the opportunities? Particularly, have you done patent searching? Because a lot of companies, particularly the larger pharmaceutical companies, don't publish in journals. They're only interested in patent protection. So the patent databases are a whole new set of information that you can review and find opportunities. Is your invention just a little bit early stage? Are some improvements likely? And are there some quick experiments? And they don't have to be to journal detail. N=2 is fine for a patent, as long as it's proof of concept. That could be done to support an inventive aspect. So other opportunities you might have, trade secrets. So in order to keep something a trade secret, you have to have your confidentiality agreements, your non-disclosure agreements really watertight. And you have to make sure that all employees and contractors are aware and on board with that program of secrecy. Given that, it can be a perpetual form of IP protection if it can be maintained. However, the use of trade secrets doesn't protect you against independent discovery or reverse engineering. So it's no good if your product can be put in a mass spec and the details determined straight away. And you also might inadvertently lose your IP position if one of your disgruntled ex-employees wanders off down to the competitor down the road and spills all. Another way for a lot of inventions, and this is particularly for things like health apps, is sometimes putting your money into registered IP is not the best way forward for you, and it doesn't give you the best bang for your buck. It might be better value to put your money into marketing. Be the first and best. Acknowledge that there will be me toos, but be the product that is asked for by name. And that could be a way forward. I'll now hand back to Dan to talk about searching quickly.
Okay, thanks, Pen. So there is more than one type of patent search, and if you've had a patent search done before, it was probably most likely a novelty search to see if your IP is patentable. You might be surprised to learn that novelty searches really provide no assurance that your IP isn't an infringement against an existing patent. So to avoid getting in this kind of trouble for selling a product or offering a patented service, you really need a patent infringement search, otherwise known as an FDO, or freedom to operate. They go by some other names too, including product clearance, patent clearance and infringement clearances. The purpose of an FDO search and analysis is to assess the risk of patent infringement associated with your own commercial activities. The patentability searches typically overlook the claims when they conduct a search, because the primary issue in that sort of search is figuring out what the client's invention whether the client's invention is in fact novel or has been published before. The patent claims are generally broadly drafted to cover concepts that go beyond the preferred embodiments that are discussed inside the specification. An FDO search might not be exhaustive, and a certain level of risk still remains, even if your FDO opinion says otherwise. Even if it appears there's no reasonable way that your business activities would infringe a particular patent, favourable FDO opinion doesn't prevent a patent owner from threatening legal action. And indeed, some patent owners use the high cost of litigation to shake down competitors that lack the financial resources to fight a protracted lawsuit. Monitoring your competitors by searching IP Australia's online register is a useful way to track new filings of your competitors. So if you know the company names to look out for, it's relatively easy to do, as well as new acceptances and grants of their applications. There's a link provided on this slide to IP Australia's online register known as AusPatent. Similar online registers are available at all the patent offices of the major jurisdictions throughout the world. Another way to monitor your competitors is by searching the Therapeutic Goods Administration and searching the Australian Register of Therapeutic Goods at the TGA. That can help you identify potential future market entries of generics manufacturers. Keeping in mind that an application for ARTG registration isn't of itself an infringing act, but it can flag for you that perhaps something's about to come off patent and someone's entering the field in that zone. That pretty much wraps up what we have to offer today. And we'd like to open up for any questions that you might want to ask through the chat function available in Zoom. I do have one question to kick off with. It's from Ninad. How much extrapolation of claims is allowed? For example, if other alcohols are in the specification and the claims only relate to ethanol, then does the claim all alcohols, or if other alcohols are not there in the specification? So I suppose to focus on the first aspect of the question, how much extrapolation of the claims is allowed, I think Pen was talking about principles, general application, which is something that's popped up consistently in all the decisions on support. It should be plausible to someone who's skilled in the art that whatever the claims are extrapolated to would work with the invention. So, you know, there's...
With the ethanol example, ethanol, if you've listed ethanol, then perhaps isopropanol, a few other small organic solvents around that, but you would not use some huge petroleum solvent. That would not be reasonable extrapolation. You look at the ones that, if you think of it as a dot point in the middle, the example that you have, what is reasonable in a little circle around that? Not wildly out in the periphery, or something that, things that are reasonable. I know reasonable extrapolate what's reasonable, but as a skilled person, what kind of things could you look at on your shelf and go, oh, that would probably work? That's kind of reasonable extrapolation.
And so we're talking about support here. And I guess one point I'd like to make about it when you're wanting to broaden your claims is that it's very useful if you can provide some kind of plausible scientific mechanistic basis for what you're attempting to claim. So let's say if you wanted to draft a claim where it could be ethanol, methanol, isopropanol, butanol, and yet you only have an example whereby you've used ethanol, which is one of the intermediate ones of those, then perhaps your specification would also need to talk about the polarity of the solvent, provide some data around that, the polarity of whatever it is you're dissolving in that solvent, data around that. And then if you could match those two things up and provide some kind of plausible scientific basis for the fact that butanol should work equally as well, then you'd probably be able to claim that. But taking a step back from support, if the questioner is really asking us about infringement, that's a slightly different matter. So if what you're saying is, okay, the claim, it only talks about ethanol, but can this person over here who's using isopropanol be sued based on that claim? The short answer to that in Australia is no. The claim will not extend to covering the scope of other solvents not explicitly recited in the claim, because we don't have this thing called a doctrine of equivalence in Australia. There is such a thing in the US, however. So in the US, yeah, it could go that way, but not here.
Okay, I think we need to wrap it up now. We will look at the questions that have been submitted, and we may be able to answer some of them by email, or just email us.
Ninette's just responded and said, yes, the question was about infringement. So I'm glad we picked up on that.
Okay. Okay, so in that case, what you would do, you wouldn't mention ethanol in your claim. What you would talk about is a solvent, and then people would need to refer back to the specification to work out what solvent encompassed, and solvent would encompass ethanol, isopropanol, because that is supported in the specification. So that's why we try and leave the claims as broad as we can. And we wouldn't say extract using ethanol, we would say extract using an organic solvent, and then people would know to go back to the specification to work out what organic solvents fall within that definition. And that's the way that you avoid infringement. But we do have to wrap it up now. I'm sorry.
I would just to reiterate that if the reason for your question was that you are wishing to avoid infringement, then in Australia, all you would need to do is not use the exact same solvent that they recite in the claim. But in other countries, that may not avoid infringement for you. So be careful. That's all.
Yes. Okay. But talk to us.
Yeah.
Is the overall. Okay. We need to get off because there's another talk coming up to this one.
Well, thank you so much for joining us today.
Thank you very much, everybody.